State of Oregon for Multnomah County is now in session. The Honorable Christopher Ramirez presiding.
All right, please be seated. And Mr. Overstreet, if you want to call the case.
Yes, good morning, Your Honor. We're here for State of Oregon versus Nancy Crampton Brophy, case number 18CR59251. Appearing on behalf of the State of Oregon, Shawn Overstreet, Overstreet, bar number 114859. Ms. Brophy is present, and today is day 13 of trial.
All right.
Good morning, Your Honor. Nicole Herman, HERMANN, bar number 126353.
Good morning, Your Honor. Madeline Loeb, spelled L-O-E-B, bar number 173970.
And for defense?
Good morning, Your Honor. Chris Weinmiller with Ms. Brophy. Weinmiller is W-I-N-E-M-I-L-L-E-R, and my bar number is 863177.
Good morning, Your Honor. Lisa Maxfield appearing with Nancy Brophy. My bar number is 844337, and my last name is spelled M-A-X-F-I-E-L-D.
All right, just a few preliminary things before we get to the motions. We have lost a juror who's come down with COVID, and the juror that we lost, Ms. Liu, I think has the number for that. I'm sorry, juror number 17. Do you know where that juror was seated? All right, so fourth from the right in the back row. So I just wanted everyone to be aware of that, and that brings our first alternate into the presumptive 12. And do we have the number for the first alternate?
First alternate is number 46.
Number 46. Also today, we will need to break a little early for lunch at about 11:45. And also, given that we've lost a day, we can use Fridays as the trial progresses, but we can't use this Friday. I don't know if that throws anyone off or not. It didn't appear to, given the defense list of witnesses I got.
Your Honor, we were scrambling to move people around this week, so we were going to ask the court not to have court this Friday.
Okay.
Can I just ask for a new one of these?
Sure.
This one is not letting
I'll
me hear
see if we have one.
the court.
Are you not hearing it?
Just not hearing anything.
All right, we'll see what we can do here.
Too far away. Yeah, and too late in time.
Oh, sorry. Let me get it out of my earball.
Because it's good, it's just
No sound.
how bad it's pretty.
I just want to make sure
There's
if
always
it's singing,
that.
it's good.
In the defense exhibit, the same place they've always been.
Is this working out?
Can you talk or
Is that
something?
good here?
Yeah. How's that? Can you hear it?
Right here.
Okay.
Okay, well, we'll just give you this one.
Okay, thank you.
You just copied and pasted and just said like replace old. There were no, I just only moved in one. He didn't.
Oh, okay, okay.
I'm pretty positive.
Okay.
I did it quickly though.
Yeah.
I was scrolling our list and their list at the same time. Sure.
Does that one work better?
Let's find out.
Okay.
No, only the ones.
Could Your Honor say something?
Yes, can you hear me better now?
Yeah, Houston, we have lift up. Thank you.
All right, okay, and I can always speak louder too if needed. I know sometimes my voice gets quiet. All right, so we do have a number of motions to discuss. To me, it makes sense to start with the motion for judgment of acquittal. I have read the motion. Does defense want to add to it orally in any way?
No, Your Honor.
And does the state want to respond?
Your Honor, I simply just say, I think taking on the light most favorable to the state, that the state has produced enough evidence in this trial that a fact finder could find Ms. Brophy guilty.
All right, I do agree in the light most favorable to the state that a fact finder could so find. So I'll deny the motion for judgment of acquittal. The next thing I think we should likely take up, and I think there's sort of two that are interrelated. There is the state's motion to exclude hearsay evidence. And then there is the defense motion to admit texts. Well, there's a response to that, of course, but there's also a motion to admit texts between Ms. Brophy and her husband. So they are sort of two distinct areas, but it seems to me we can probably take them up at the same time. I guess what I mean by that is first we can focus on the issue of non-text messages. I will first state my understanding of the state's objection and the defense position, but I may be off, so certainly you'll both get a chance to address this. At this point, there's a number of witnesses. I don't know exactly what they're going to say, which is sort of the difficulty with ruling on these kinds of statements. But leaving the text messages aside for a moment, as I understand, part of the defense argument is that they would intend for these various witnesses to say, in my mind, what are two different things. The first, that Ms. Brophy told several witnesses that she had bought a gun kit, and also that she bought it for the reason that she was going to use it in some capacity as research for a book that she was writing. So just to give everyone, before I hear the argument, my thoughts at the moment, I would tend to agree that the statement, I bought a gun kit, would be admissible because I think it would not be hearsay, as wouldn't be offered to prove that she had in fact bought a gun kit. I don't think that's really in dispute. I think the purpose defense would be introducing that statement for would be to rebut the inference that she was trying to keep the purchase of this gun kit secret and not tell others about it. Now, the reason why she bought the gun kit for the purpose of doing research on a book, I do not think would be admissible. To me, it seems like that would be offered to prove the fact of the matter asserted, the purpose for which she had bought the gun kit. And I don't think it fits the exception to hearsay under 803.3, state of mind exception, because I believe it's a statement of memory or belief to prove the fact remembered or believed. I will let the sides know that in looking at this issue, before taking the bench, I reviewed a number of cases. I do want to put them on the record, in case some appellate court disagrees with me. But I did read State versus Mendez at 308 Oregon 9, a 1989 case. I read State versus Richardson at 253 ORAP 75, a 2012 case. State versus Blaylock, 267 ORAP 455, 2014 case. And State versus Bemet, or Bemet, I'm not sure how you pronounce it, 363 Oregon 760, 2018 case. And also State versus Clegg, 332 Oregon 432, 2001. So having said all that, I don't know if that encompasses everything that the defense is trying to introduce with these various witnesses. I mean, I know there's overlap into another defense motion having to do with the state of the marriage between the two, and I don't really want to get into that just yet. Let's sort of start with this. Is there more that defense is seeking to admit that, well, go ahead, Ms. Maxfield, go ahead.
Here, I think as we lay out in our memo, it's really more than the purpose, why she bought the gun kit. We're talking about a future plan. In other words, she's expressed to different people her plan to use that gun kit in the future as research as she continues to develop this storyline. We believe that her expression of her future plan or her future intent for the use of this gun does fit within the state of mind exception. And we would ask the court to admit it for that future purpose that's expressed to her various writer friends. This is an ongoing process. This is a storyline that gets developed over a series of months, not on one day or the day that she bought the kit. And the fact that she has an ongoing plan to use that kit as she continues to develop the storyline and as she continues to research the storyline would fit within OEC 8033.
And am I missing, other than that argument, is there other things that you want these, that you anticipate the state's going to object to, that these, I don't know if you can anticipate an objection. I guess I'm just trying to find out, have I centered in on the right issue, or is there more that defense wants to elicit from these various witnesses?
Well, I think also that offering the statements to provide some context as to why she would have told these people that she had purchased a gun kit. In other words, that it came up in the context of her exploring with them the ongoing development of this storyline, where she's asking people for their input regarding this storyline, whether it's a practical storyline. And the fact that this statement regarding the purchase of a gun kit happens within that context, I think is important. So in that regard, I think it's not hearsay. I think it offers context for why she would have told them about the purchase of the kit. I think where the court and the defense kind of maybe have split ways here is that the court is focused on the statement about the purchase of the kit, which always would be past tense. But the defense is more focused on the defendant's statement regarding the future use of the kit and the fact that she talks to her various writer friends about how she intends to use that kit as the story continues to develop. There's no way to explain the future tense without offering up the past tense.
Okay. Anything more?
Is there more that I need to say? I'm not sure that there would be more that I would ask the witnesses beyond the fact whether they had a conversation with our client about an ongoing story, what that storyline was, whether they offered criticism or suggestions to her regarding the ongoing storyline, and whether as a result of that conversation, the client or the defendant disclosed the purchase of the kit and her ongoing purpose for the kit. But those would be the factual examination lines that the defense would pursue.
All right. We'll hear from the state.
Yes, Your Honor. I think, as Your Honor already identified, I think we're talking about two statements, although said maybe at the same time. We're talking about two different statements. The first being, I bought a gun kit, and then what the purpose was. And I guess the testimony that we're concerned about, based on defense investigator reports, are the disclosure of the purchase of the gun kit after the fact, as you've already identified. But there's also disclosure that when she bought the gun kit, that was the plan then, that it was for the purpose of doing research. And what the witnesses, I believe, would say is that it's Nancy Brophy talking about what she was doing back when she made the purchase of the gun kit and what her plan was at that time. So she already had that plan. She already developed that plan back then. The idea that it's ongoing, first of all, I don't think that there's any witnesses that are going to say that Nancy said, I plan on in the future using this gun kit for research. And I'm basing this on defense investigator reports. So if there's something else that defense has, it hasn't been shared with us, so we don't know that. What we do have is witnesses, specifically, I believe, Jesse Smith, saying that Nancy had disclosed that she had purchased this gun kit because she had a plan to write this book, but that was done after the fact. So until there's evidence, I suppose that maybe could be done in a 104 hearing from a witness that defense thinks is going to talk about a future plan, I don't think that this type of testimony should be allowed to be elicited.
Your Honor, could there is one other line of questioning that I forgot to mention. These writer friends fall into two camps. One of the writer friends, I think it's Linda Smith, would say that before Ms. Brophy bought a gun kit, that she had talked to Ms. Smith about this story that she was developing, and she told Ms. Smith that she had a plan to buy a gun kit for the purpose of this literary research. So, but she said she has no idea whether Ms. Brophy actually bought the kit, that she had just expressed to her plan to buy a kit as research for the story. So she kind of falls in a different camp than the other writers.
All right, well, I think with Ms. Smith, then, I would need to, I was provided a do we still have the list of the defense witnesses? Is Ms. Smith slated to testify today?
Not today, Your Honor.
No, I don't have it on the floor. Yep. We can have a 104 hearing before she testifies, just so I can get a better sense of what exactly she would be saying. I'm sorry, I didn't. So here's where I land on all this. And I will say to defense, to the extent you think witnesses might testify differently than what I'm surmising, we can have a 104 hearing. But generally speaking, I will allow witnesses to discuss that Ms. Brophy had told them that she had purchased a gun kit. I agree that I disagree with defense regarding a continuing plan. In my mind, if a person has purchased a gun kit at a point in time where they had a plan to use it as research for their story, and they are now recounting that to another individual, I think it does not fit within the hearsay exception, even if the plan is ongoing, even if it continues. However, if you believe any particular witness is going to say something slightly differently, we can take it up. But at this point, I would instruct you as your witnesses prior to them taking the stand, let them know that they can talk about Ms. Brophy mentioning she bought a gun kit, but not why she bought the gun kit. And,
Your Honor, would the court allow these witnesses to testify to what they told Ms. Brophy about her ongoing storyline and what was practical about it and impractical about it, their own statements to Ms. Brophy?
State?
Well, that's hearsay. I mean,
No, it's the witness saying this is what I said.
right, which is an out-of-court
Out-of-court
statement,
statement.
which is proven. That's exactly what
Yes,
it
I would tend to agree that it is hearsay with any one of them. If you feel it's not and we want to take it up in a 104 hearing, we can. You know, part of the difficulty here is me not knowing precisely what these people are going to say. And so I'm being asked to rule on statements without really knowing what the statements are. But I would generally think that someone repeating what they had said in the past is hearsay. So let's move on to the text messages. And just so I have some sense, because we're talking about apparently 3 years of text messages, I have no idea how many pages this looks like, if it's printed, and what quantity of information we're talking about. Let me just ask, has it been printed out? Is anyone able to tell me?
I can tell you it's 371 pages.
Okay. So again, I have read the motion, and again, I want to give sort of my provisional ruling. But of course, I'm going to give defense the chance to fully flesh out the record. But as I understand it, defense believes that the entire 3 years worth of text messages are admissible and relevant because they rebut an inference that Ms. Brophy and her husband had a souring relationship, or that the relationship had started to become different towards the end, close in time to Mr. Brophy's death. Now, the defense cited, and I do want to comment on this, the case of State versus Davis at 336 Oregon 19, page 26, 2003, for an argument that, sort of anticipating a state argument, that attenuation in time doesn't necessarily affect relevance, it just might affect the strength of the evidence. I'll let defense know I didn't read that case that way. As I saw that case, when it was up on appeal, the state had already conceded the relevancy of the evidence. The argument was whether or not it should be kept out under a 403 balancing test. So I didn't see that case standing for the proposition that defense did. I am not inclined to allow 3 years worth of a text message exchange to be admitted into evidence. I think above and beyond relevance, there are any number of other objections. The state has generally objected to hearsay. And with any particular statement, I can't know whether it's hearsay or meets an exception until I know what the exact statement is. So where I am right now is of a frame of mind that if defense wishes to identify specific text messages, or perhaps a category of text messages closer in time to Mr. Brophy's death, we can have a meaningful conversation, but I can't review text messages over a 3-year period to see which ones might be exceptions to hearsay and which ones might not. But go ahead, Ms. Maxfield.
Your Honor, we'll provide the court with a printed out copy of these, and we can revisit this issue once the court has had a chance to look at those. But the state has talked about a period of financial despair that they say begins in 2016 and extends to Mr. Brophy's death in 2018. They presented expert testimony for a couple of days about what was going on financially and asking the jury to imply that somehow this had caused serious problems or tension within that marriage, serious enough to cause a murder. What's important about these text messages isn't just what's written. What's important is what's not written. The fact that they continue to be supportive of one another, the fact that they deal just day to day with what's going on in their lives with humor, the fact that they're supportive of each other on a continuous basis. It's that there is no tension displayed within 3 years of text messages and that there is no change. The state has consistently argued that something went wrong here and have argued in their opening statement that on the quote surface, they appeared to be a happily married couple. Well, it's more than just the surface. They appear to be a happily married couple in their day-to-day communications. The state's extended the relevant period back to at least as far back as 2016, and that's where these text messages pick up. Oh, Ms. Weinmiller says 2015, and that may have been the financial evidence that was presented here.
All right.
But what I'd like to do is to revisit this after the court's had an opportunity for us to offer the specific exhibit
Sure.
in a
Sure,
hard copy form.
we can do that. And since we're not, in trial on Friday, I'll have some time to look at it. So I guess since I haven't even had a chance to see the text messages, I'm not going to ask for a state response now. You can give it if you want, but we can take this up at a later point in time.
And Your Honor, maybe I'll just briefly address it so it kind of gives Your Honor some context as you're going through it. The state's position, and I won't go through the whole, there's a foundation issue, then the hearsay exceptions and or non-hearsay exceptions, and then relevancy is sort of the outline of what we're looking at it. But I think what's important to note is that the text conversations, as I said, there's 371 pages. They're pretty short conversations, usually less than 5 texts per conversation. There's often weeks or days that go by between text threads, and many of the texts are not answered. They're like, for example, we just pulled a page 35 that is a series of 7 text messages in total, which is 3 different conversations. And the first one is, prep more, we will have a full house. And the response from Ms. Brophy, and the response from Mr. Brophy is, what does that mean? That's the end of the conversation. The next text is, home soon, lunch plans. 2 days later, unanswered. So these texts are not relevant, nor do they show any of the things that defense is purporting. They're also, and so I guess I'm trying to go too much into it, and I won't, but the state's kind of perspective is there may be certain text messages that are either non-hearsay or subject to 803 sub 3 and would come in for that purpose. And we acknowledge that that may be true, but the entirety of the texts don't come in. There's a relevancy issue, but there's also a rule of completeness issue. And I think in defense's motion, they're arguing that they should just all 371 pages of 3 years should come in to make the conversation complete. And State v. Tooley very clearly states that is not the rule. And so I think that the remedy is for them to identify specific text messages or specific strings of text messages and then to look at those strings. So that's sort of, in summary, the state's perspective.
So we will take this up later. I guess what I would say to defense, I will certainly consider and listen to argument that the text in their entirety should come in, but I would also suggest to defense they identify as an alternative some specific text messages we're talking about. I'm not ruling today, but I, just based on the recitation of what was on page 35, it's hard for me to imagine that everything within a 3-year period will be relevant. But I'll certainly not rule today, and I'll review the text messages. So let's turn to defense motion to admit statements under 803.3 and lay opinion. I think I understood the lay opinion portion of it. I guess what I was a little unclear on, Ms. Maxfield, is so as I understand it, the lay opinion is essentially that people would testify that they knew the Brophies, that they were around the Brophies, they had a sufficient basis to form an opinion, and their opinion was that they had a healthy marriage, or words to that effect. I wasn't sure if something else was contemplated under the 803.3 portion.
Your Honor, I believe this is.
No, it's not.
Uh-oh.
I don't have it here.
Your Honor, we have a division of labor issue here. Can
Sure,
we come
sure.
back to that so I can read whatever it is I need to share
Right,
with the
okay,
court?
all right. Then let's turn instead to the defendant's motion to admit the former testimony of Shawn Massengale. I guess at the onset, I'll ask the state if they object to that.
Sort of. When we received the request, I guess what I would say is we agree that she is unavailable. That's not the argument.
Okay.
She, I believe, is in a very serious, has a serious medical issue that is making her unavailable, so we would agree with that. But I think the question is, do we just allow in the transcript? And that is what we're objecting to, just allowing in the transcript in its entirety. When this was first brought up to us, our response was, well, maybe there's something we can work out. What is it that you are actually looking to offer from that transcript? And we did not receive a response to that reply. So we don't really know what it is defense is really trying to introduce from that transcript. If we knew that, I think there's probably some stipulations that could be made. Primarily, just for an example, I believe Ms. Massengale had intended to show up earlier that morning on June 2nd. And in fact, we see her on video driving by later than she had thought that she was, one, supposed to be there, and later than she thought that she had actually arrived. But that's not captured in that transcript, the fact that she's seen on video driving by and actually arriving at a certain time. And so I just use that as an example of when we're talking about the exception in 804.1D, that rule about unavailability, the person who's objecting to the testimony or the transcript, which is the state in this case, this court has to determine whether we had a similar or a equivalent motive when that testimony was taken. And this is where I think the defense fails to show that, is because that motion hearing that testimony was taken in was regarding the destruction of evidence. And so that's how the questioning was done. The state was very limited in questioning this witness regarding her actions that morning in relation to destruction of evidence. So that's certainly much different than the time that she arrived, the time that, and then the proof on video that she arrived at a later time. That's not addressed in that motion. So I just think if defense would work with us, we could probably come up with some sort of stipulation. But if not, then we are objecting to the entirety of it, and I don't think it passes the 804 test.
Well, so let me ask this. Within the transcripted portion, it sounds like the state's objection, if I'm understanding right, would have to do with questions and answers given to the time of the morning she arrived there. Is that right, or are there other parts the state would be objecting to?
No, we're not objecting. The statement in the transcript where she says, I intended to be there earlier, it's the problem we have with that is it's not a complete statement that we would question her about.
Okay, so that's the main thrust of what.
I think that's the main part of it. I think there's some other things in there that are that we would expand on more, but I think just for purposes of this particular motion, I'm using that as an example of a question or a line of questioning that the state did not have the same motive in that hearing that we would now if we were given the opportunity to question Ms. Messingale now.
Okay. And who's addressing this for defense?
I am, Your Honor. So, Your Honor, when I read this transcript, I imagine that the testimony at trial, were Ms. Messingale still healthy enough to come here to join us herself, would read very, very much like this transcript. I agree that there probably would be some questioning of her about the fact that the video shows that she got there just a little bit later than she describes, and I think we can address that with a stipulation. But I think rather than narrowing the transcript to stipulations, what would make sense is to fix whatever problems Mr. Overstreet thinks there are with respect to questions not asked during the earlier hearing. If those are as clear as we have her on video coming a little bit later than described, then we can stipulate to that. I'm not sure that there really is anything other than that.
Well, let's do this then. Why don't I hold off ruling on this, give the sides a chance to talk, and we'll see whether or not the things that the state might object to can be addressed with stipulations. And if they can, great. And if not, then we'll take this up again. All right, so just moving right along, and I think we're getting close to the end of these. There was a defendant's motion to compel informant witness information. So I guess I'll let, I've read it, but I'll let defense say what they'd like to say on that.
Your Honor, first and foremost, what we would like to say is that we do not think that if the court allows this testimony during the rebuttal case, we do not think that there is any way that this case will finish trying by May 20th. To respond to this would require significant investigation, significant record gathering, and frankly would require probably 2 separate, fairly substantial hearings to address issues. That kind of investigation and record gathering normally would be conducted over months or a year during trial preparations. There simply is no way to expedite that. As the court's aware, this is an unusual time that we're practicing in. There are many, many cases going up for trial. There are not many extra lawyers or investigators available who have time on their hands. We certainly do not. And we just don't have the ability to pull in resources. But even if we did, I don't think this could be done in a week or 2. I think it would take, even under the best of circumstances, many months to do this. And I just am very concerned that we've committed to the jury that we will finish by May 20th, and that simply is not going to happen if we have to try to process all of this at the same time we're completing the trial the way we plan to complete it. I understand that the state is interested in exploring this, but it's a very, very complicated piece to add in to try to parse out what this witness heard and what that means and how that relates to other pieces in the case. I think we probably would have to bring in some extra experts. If they're presenting this in their rebuttal case, that would mean that we would need rebuttal. Some of the experts that we've explored so far are people that we would need to bring in probably from out of state. And it just seems entirely unrealistic. And I think the bottom line is the state decided to initiate this prosecution when they did. They resisted our effort to set it over, as the court is aware, at the beginning of the year, and it's just the cost of that now is that it's just simply too late after they've rested to bring in another witness of this magnitude and this complexity.
So let me ask a few basic questions, because I think the sides might be assuming I know things that I don't know. First and foremost, when did defense get notice of this witness? I think it says in your motion 8 days after trial ended, but
It was, I believe it was late in the day on Friday.
you're talking about this last Friday?
Yes.
Okay. And what is this witness purportedly going to say? And I guess maybe that's a question for the state, but do you have that?
We received yesterday the audio of the interview, and I've listened to it once, but I do not have it transcribed, so they might be better suited to speak to it. I do, though, before we jump ahead, just so I don't forget to say this, we did also, with the audio or separately later in the day, receive some additional paper discovery that relates to this. And one of those, I think I have a copy here that I can forward to the court. Maybe right now I'll just forward my own, if that's acceptable.
Just the email, or just the letter? Is that all that
Well,
is?
actually, I just want them to have this first page. I think I do have a copy to leave with you, but I just was delivered.
All right,
I
let me-
haven't separated the papers out yet. But Your Honor, if you look in the lower right of that envelope, even below the envelope, you'll see a notation that prosecution investigator Robbie Thompson added. And that indicates that she received that letter that started this whole chain of events on March 8th. That was not revealed to us. We did not receive that ourselves, I think, until yesterday. And in the letter, there are written statements attributed to our client. So not only is there this issue that we've had addressed repeatedly during the trial about the obligation under the new version of the discovery statute to reduce statements of the defendant to writing, but that actually is a written statement that's attributed to the defendant that was not revealed to us again until yesterday. And I haven't counted the number of days between March 8th and yesterday, but that's a very considerable period, especially when you consider the relative complexity and difficulty of the investigation that allowing this testimony would require.
Okay, so let me ask the state, well, go ahead, Mr. Overstreet.
To that last point, Your Honor, that's not a letter written by Ms. Brophy. That's a letter written to Ms. Brophy. So these are not recorded statements of the defendant. This is a letter written from outside, sent to Ms. Brophy.
Well, I haven't read the letter, but if someone else is writing Ms. Brophy, but incorporating what Ms. Brophy told that person, then it might be. I haven't read the letter, so I don't know what it says.
It's fairly long. Some of it's hard to read, so I can't honestly say. I couldn't pinpoint something in the letter where she's recounting one of Ms. Brophy's statements. I suppose if defense has that, I would defer to them. But nonetheless, the point is this letter was written in. Did we have it in March? Yes. Did it mean anything to us then? Absolutely not. It meant nothing until last week. We didn't know who the people were in the letter that was being referred to. There were people being referred to by first name only. And the important names, for Your Honor, are Andrea Jacobs,
Is this letter from Andrea Jacobs?
No. It's from a woman named, I believe, Catherine Wells.
Okay.
And she's just, in the letter, she just says the name Andrea. That's it. Andrea. Nothing else, just Andrea. It then goes on and talks about somebody named Shawnna, Schwanna. No last names, no real further context, except for a possibility that maybe they were housed together in the jail. And so, again, what I'm trying to say is back in March, that letter really meant nothing. We didn't know who these people were. We didn't know the context because there's really not much in there. It just says something about Andrea talking to somebody else about Miss Brophy's case. That's it. There's no context really in there about that. Now, what happened was during the break last week on Tuesday, let me make sure my dates are correct. I believe on Tuesday, we identified and we're able to talk to Shawnna, who is currently housed at Coffee Creek, the women's prison. And we were able to arrange a phone call with her. We spoke with her on Tuesday, as long as I'm getting my dates correct, on Tuesday. And she didn't really have much to say. What we were asking about was, did Miss Brophy disclose what she was doing on the morning of the homicide? Because we thought, oh, maybe if they're housed together, maybe Miss Brophy also disclosed to them about her whereabouts on the morning of the homicide. Ms. Shawnna did not have any really relevant information. But then we asked the question, anybody else that you were housed with, did they tell you anything about Miss Brophy's case? That's when Shawnna gave us the name Andrea Jacobs. And she said that Andrea Jacobs had told Shawnna that Miss Brophy had disclosed to Miss Jacobs that Miss Brophy was only inches away from her husband when she shot him. So obviously that's a hearsay statement that we would not be able to elicit through Shawnna. And so we terminated our call with her. She had nothing really to offer us. And we then turned our attention to try to identify and locate Andrea Jacobs for obvious reasons. We located Miss Jacobs in a federal prison in Bryan, Texas. She's in a federal prison camp, Bryan, in Texas. And she's currently serving a prison sentence there. And so we reached out to that prison. And when I say we, I'm talking about my Detective Merrill. Coordinated with the prison down there to arrange for a in-person interview. And that was arranged for Thursday. So this was all being done on Tuesday. Detectives flew to Texas on Wednesday. And that was Detectives Merrill and Detective Brian Sims. And then they interviewed and recorded the interview with Miss Jacobs on Thursday of last week. That interview, as I said, was recorded. In that interview, among many things that Miss Jacobs said, was she did talk about how Miss Brophy disclosed to her, and to be fair, seemingly incidentally or accidentally maybe, disclosed to Miss Jacobs that she held her arms apart, Miss Brophy held her arms apart like a wingspan, and said, I was this far away when the shooting happened. She then corrected herself, Miss Brophy did, with Miss Jacobs and said, well, I mean, it was this far away, or it happened this far away, something like that. Miss Jacobs reported that it became very awkward between the two, and so awkward, in fact, that Miss Jacobs decided to change the subject, and they went on to talk about something else. I believe, I'm sorry. So that was recorded. That was then delivered to us. We made it available to defense via flash drive on Friday by 2:30 p.m. I emailed the defense and told them that the flash drive was ready and available for pickup. They did not pick it up on Friday, and did not pick it up until yesterday. But it nonetheless was made available. And the bottom line here, Your Honor, is that this is a rebuttal witness. We're allowed to develop rebuttal witnesses to what we anticipate they're going to put on as far as a defense case. If defense does not put on a case, this witness has no ability to testify. We're not asking the state to reopen the state's case in chief. I believe it's a rebuttal witness. That's the intent. We intend to file our writ ad testificandum in order to get Ms. Jacobs up here to testify, and that is in the process. As far as timeline, we anticipate we will have her here in time for the end of the defense case. So the week of the, let's see, 9th, 16th. If defense goes the next 2 weeks, then we would have this witness here for the week of the 16th through the 20th, sometime in there. The state also anticipates other rebuttal witnesses. I think we made it very clear that we're always going to be planning on a rebuttal case, given the defense's assertions of them putting on a case. So among other witnesses, she's a rebuttal witness. As far as how complicated this is, I don't really know why this is so complicated. I've laid out the, I know she took a plea deal and is currently serving out that sentence that ends sometime next year. And there's been no discussion about what the state is going to offer her in exchange for her testimony. At this point, she's just a witness. She's not a cooperating witness. She's just a witness. The only documentation that I believe is outstanding, given what the defense has asked for us in an email and put in their motion, is that Ms. Jacobs disclosed to the detectives that she had previously disclosed this information to her attorney. Her attorney at the time is now sitting Judge Celia Howes, and Ms. Jacobs said, I disclosed this information to my attorney, Celia Howes, before she became a judge. Also part of that conversation where those disclosures were made to her attorney was another lawyer named Megan McVicker. Ms. Jacobs authorized detectives to go and get those notes. She signed a search by consent form and said, and it's on the recording too, you can hear her say, you guys can have those notes. I disclose this stuff to my attorney. And so what we did with that is we took the search by consent form, we accompanied it with a subpoena, and we shipped that off to Ms. Vicker. Ms. Vicker then retained counsel, and that counsel has worked with us and with Ms. Vicker in order to identify things that are possibly responsive, i.e. these notes that Ms. Jones talked about. I'm sorry, Ms. Jacobs.
Remind me who the notes say again. I got a little bit lost. What are the notes?
Yeah,
you're talking
sorry.
about?
I know there's a lot of names flying around. I just said the wrong name too, so that's my fault, Your Honor. But Ms. Jacobs, the federal inmate with this information, said that she disclosed this information prior to Celia Howes and Megan McVicker.
I understood that part. Okay.
And then she gave permission by search by consent and on this audio recording for the detectives and us to be able to retrieve these notes.
Okay.
What Ms. Vicker did then is she then identified what she believes are responsive to that release of information or search by consent and the subpoena. But they wanted to double check with their client, understandably so, wanted to double check with their client that these are the notes you wanted to in fact turn over to the state. That hasn't happened yet, as far as I'm aware of. So they've identified these notes, but they haven't turned them over to us yet because I'm unsure or unclear on whether they've actually had that opportunity to talk to Ms. Jacobs at the federal prison about whether she really wants to do that or not.
Okay.
Once that occurs and if and when we get these notes, we certainly will provide them in discovery, and I anticipate that will probably happen in the next couple of days. Certainly, I would think by the end of the week, based on my conversations with Ms. Vicker's attorney. I've turned over all that information. Everything I just said, I put in an email and I turned that over to defense. I even included the email chain that I had with the attorney for Ms. Vicker. So they have everything. There's really nothing left for me to turn over. I know they think there's something more nefarious as far as like these deals or working with the feds or things like that, but that's just simply not true. That's not something we're doing. We went straight to the source once we found out who this person was. And I guess technically at this point, it's actually kind of moot until defense puts on a case and the state has an opportunity to rebut it. I just anticipate that
So this may be coming back up. All right. In the meanwhile, have you provided to defense a criminal history for Ms. Jacobs?
So I have not ran the LEDS report yet. That is something we certainly can do today and get that to them. They're obviously aware of her conviction that got her in federal prison. I think they put that in their motion, and actually they put I think, was it a judgment? I think they put the judgment that I didn't even see before. So I think they might have actually had a little bit more information than we did. But we certainly, to your question, we certainly will provide a LEDS discovery regarding Ms. Jacobs.
All right, so given that this is a little bit early for me to rule on this motion, since state has announced an intention to call this person as a potential rebuttal witness, but we don't know yet whether or not they'll call them as a rebuttal witness. So I'm not going to, I guess it's difficult for me to rule on this because what defense is essentially asking for is information about contact between the state or the government and this witness, sort of centered around this testimony. And what I'm hearing from Mr. Overstreet is they don't have that. But go ahead, Ms. Weinmiller. What else do you want to put?
Well, Your Honor, we don't really have much information yet that puts a time frame on these alleged exchanges between Ms. Jacobs and our client. But one thing that we didn't specify in this motion to compel, and I want to include here now, is that from some of the statements that were included in the audio that admittedly I've only listened to once so far, it appears that topics that were germane to the litigation that we had before Your Honor in November of 2020 are the conversation appears to be replete with references to that litigation. That's when we were arguing the motion for destruction of evidence and some of the things about ballistics. We would like to know whether in that time frame specifically, and this question is much more general, we want to know just in general, but we would like to know specifically closer to that time frame, whether the state, through any of its agents, either the prosecutors directly, Ms. Thompson, the DA investigator, Detective Merrill, any of the other detectives, anybody from PPV, anybody from MCSO, had put out the word amongst the inmates who were housed with Ms. Brophy at any point during her incarceration for this case, whether the word went out that they were interested in information about her and about this case. We think that that is a critical part of uncovering what happened here. We haven't seen the notes yet. We don't have the benefit of knowing what her attorneys say. But that is something that I think the court could direct them to provide now. And certainly, given the time constraints for developing this information, I don't think it makes any sense at all to wait on directing that information of that nature to be provided. I also will say to the court that we, although I can't present the court with any substantiation of this now, we understand that Ms. Jacobs is actually currently under investigation for events for which there would be venue in Multnomah County, that there is a state prosecution. We don't know whether that's being undertaken in conjunction with the DA's office in Multnomah County. But there is other pertinent information that wouldn't show up in the form of convictions that certainly could motivate her in this context. And I also
Do you have information on what kind of investigation?
Medicaid fraud, apparently in the hundreds of thousands of dollars range.
We don't do that.
Okay.
Federal.
Or DOJ.
No, it's the state. And she's been appointed counsel, apparently, in Multnomah County for that purpose. State counsel, a county counsel, I mean, the public defender, not federal.
Okay.
It's not in our office. That's all we could say.
So there is discovery that I think has to be ordered and has to be forthcoming. But again, Your Honor, getting information out of the federal government, as I'm sure Your Honor is aware, is just not something that comes quickly or easily. There's a very, very complicated process that one has to follow through the CFRs. It certainly isn't something that I would expect any of them to voluntarily offer up for this purpose. And I just cannot imagine how we would come up with the resources to properly investigate this. And as I'm sure has occurred to the court, it's the sort of investigation that has to be done before one even makes a decision about whether to call their client to testify. So the time constraints here are very, very significant.
Well, of course, I have no authority to order the federal government to do anything.
Right.
Now, having said that, and so it sounds like I don't need to rule on this right now, but it sounds to me like, if I'm understanding the defense motion, on the one hand, you're asking me to order the state to turn over things, some of which may be in their control, some of which may not, and to the extent things are in their control, I'm happy to order them to do that. But it sounds like you're also moving for me to proactively exclude a witness, which I'm not willing to do.
We're not asking you to do that now, Your Honor. We're asking for this to be set up so that we can litigate that issue once we have sufficient information to convince you that that's the appropriate course of action here.
Well, what I will do is I'll direct the state to, if to the extent it exists, provide information about any state or government agent who, defense used the phrase put out the word. I'm not entirely sure what that means, but to the extent a state or government agent sought information and made it clear that they were interested in information from inmates about Miss Brophy, if that exists, I'll ask you to turn it over. Go ahead, Mr. Overstreet.
I think I can answer this, and of course I'll double check with the partner agencies, MCSO and PP. Actually, I can't check with MCSO. I wouldn't have any idea who to talk to there.
Oh, you could find out, I would think.
No, I mean, we haven't had any communication with MCSO regarding any inmate.
Okay.
I guess that's what I mean. So I wouldn't have a person to go to ask, did you ask the inmates whether there's any information or something? I guess that's what defense is asking. These sort of eliciting from potential people that were housed with Miss Brophy, I think is what they're after, is any, whether us or any partner agencies did that.
Sure, but there's got to be someone who heads MCSO's investigations. I mean, you could check with that person.
I suppose. I can just say there's been no conversation, so I don't.
Okay, all right.
I suppose we could try to do something like that, and we'll commit to doing that. And as far as PPB, we'll check with them as well. What I will say, Your Honor, is what sparked all of this was these women who were housed with Miss Brophy, and why they went to their attorneys, and specifically Miss Jacobs, is because defense investigators were in the jailhouse asking about potential witnesses to support Miss Brophy. That's what caused Miss Jacobs to go to her attorney, because she didn't feel comfortable doing that. She had heard Miss Brophy say these things to her that were concerning, and she did not want to be a witness. That's what sparked all of this. And so she went to her attorney. Her attorneys never approached the state about this information. They never came to us or anyone in law enforcement and said, one of our clients has information, she'd like to provide it to make a deal. That never happened. And what Miss Jacobs says about that is that she didn't want anything to do with it. She said, I heard this information, I wanted nothing to do with this. I didn't want to use it. I didn't want to go and be a snitch, as a lot of people who end up in prison have a desire to not be a snitch. And so nothing happened with this information. This did not come to us by us going to the jail and asking these questions until last week when we reached out to Shawn. That's the only time that we've gone and tried to find information regarding people who were housed with Miss Brophy. So I think it's a long way of answering the question of when did we do this? When did we go and elicit this? Last week. And I just disclosed everything that we did. There has not been any other attempts to find any witnesses in the jail from the state to talk about Miss Brophy in any statements she made. There just aren't any. I will still check with PPB, and I will commit to trying to find somebody with MCSO. But I think based on what I've experienced over this past week, that simply is just not out there.
Well, also now the defense is saying there's a Medicaid fraud case investigation, they believe. And I know you're saying that you don't know that anyone in your office in particular is investigating this, but I would ask you to check on that too. It may be some other state agency that's conducting such an investigation. I don't know, but I will direct the state to look into that too. Obviously, if Ms. Jacobs testifies, defense would be entitled to information that they might be able to use to attack her credibility. And we can have arguments later about what specifically they could use, but I would ask the state or order the state to look into this assertion that Ms. Jacobs is undergoing a state investigation right now.
Of course, and Your Honor, we have already looked in our internal system. There is not anything in our internal system. There's also nothing in OECI regarding an open case or anything like that. So I think the last thing for us to do would be to run this LEDS report like we've committed to. And I think that will comply with Your Honor's order.
Well, I could see a situation where some entity, I don't know if Medicaid has their own investigators. I mean, I could see a situation where perhaps they were investigating this and your office had no idea it was being investigated. So I would ask you to see if there's a contact with Medicaid. I honestly don't know their structure, whether or not they have investigators, but I would certainly direct you to look into that and find out.
Okay, we'll see what we can find out.
And Your Honor, quite a bit of that discussion ended up revolving around MCSO, and I want to be clear that our primary concern has to do with whether the prosecution office or PPB initiated those contacts with others, and I would ask that the court specifically ask them to review their files. Mr. Overstreet says his recollection is that nothing like that happened. I would like a more affirmative and detailed assurance that there's nothing in their files, and I'm asking because we believe we may end up then presenting some evidence to the contrary.
Okay, I will direct the state to check its files to ensure that. Did you want to go ahead, Mr. Overstreet?
I just want to make sure I understand. Checking our files to ensure that we didn't annotate any attempt at finding a witness?
Right, beyond, not limited to Ms. Jacobs, but to all inmates who might have had contact with Ms. Brophy.
Well, I guess I'm asking, I need some context because I don't know who that is or what we didn't do that, so I don't know what they're looking for. If they have some information, I think that they should be shared with us so we can then maybe go from there, because maybe that will.
All right, so let me ask you, Ms. Weinmiller, Mr. Overstreet is now saying we didn't do that, not like my memory is that we didn't do that. Anything more you want to say about it?
Well, I'm asking that they do a file review. We will move forward and let the court know when we have a witness to present, but I think it would make sense for them to more thoroughly review their records first.
All right, I'll ask you to review your file.
Okay.
All right, so then the last thing that we have, and I'm not sure whether or not this is something that we want to take up right now, but defendant's motion to identify other acts evidence it intends to admit. I mean, obviously, well, I don't know. Let me ask defense, because I thought we had addressed this earlier during the state's case in chief, but go ahead. I'm not quite sure what this motion is getting at.
Your Honor, we're not entirely sure how much this would encompass either, because obviously it would be the state that intended to raise these issues, but there are, in addition to the things that we've already brought to the court's attention, we received, I think on Sunday, a report from PPB of an interview that they'd done with James Denny, who we intend to present as our first witness. That came to us on Sunday, although it had been generated in 2019. Apparently that had been overlooked in the discovery process. And one of the questions that Detective Merrill asked Mr. Denny implied, or seemed to be getting at, whether Mr. Denny had some reason to believe that our client had somehow been responsible for this fire in their home many, many years ago. And it seemed like he was getting at the question of insurance fraud, whether somehow she had set her own house on fire for the purpose of collecting insurance. And it was surprising and jarring to read that, but I have no idea what that's about. And certainly if the state intends to make that sort of suggestion with witnesses, we think it's incumbent upon them to bring that to the court's attention before the jury's ever seated. The other specific instance that's come up so far in this trial that caused concern and the request that they be directed just prophylactically to bring those kinds of things to the court's attention outside the presence of the jury before questioning on cross-examination is, and I don't remember now exactly which witness it was, but Mr. Overstreet had suggested that somehow our client had a financial interest in serving as the executor of her brother's estate in Texas. And that just seemed like a complete non sequitur. I have no idea what that has to do with anything. I also think it's factually untrue. But again, it seems like it has nothing to do with anything pertinent to this case. And so if there is some sort of other act there that they intend to try to draw out further, either with our client in cross-examination or with some other witness from the family or otherwise, would like that aired with the court ahead of time.
So let me first ask, is the state planning on asking Mr. Denny questions regarding this earlier fire in the home?
Regarding the fire, possibly, just that that was disclosed and when, that Ms. Brophy disclosed to him that there was a fire and when that occurred. I think there's some discrepancy about when people believe this fire occurred.
And what's the relevance of when the fire occurred?
Because there's already been testimony to that, Your Honor, about this fire, and it's sort of a point in time that people can say, well, before the fire or after the fire, because some people are having a hard time recalling when
All right,
certain
so
things happen.
other than it setting a point in time, is the state planning on getting into questions about who Mr. Denny thought was responsible for the fire or what he thought caused it?
Absolutely not, Your Honor. If we were intending to sort of allege some sort of insurance fraud, I think we've done a horrible job at that because we haven't elicited any testimony like that, and we certainly didn't make any statements in opening about some sort of insurance fraud. We haven't alleged that. We haven't asked the jury to draw any conclusions regarding the cause of the fire or anything, just that the fire happened. And that really, it's just for a point in time reference. We're not alleging that Ms. Brophy started the fire. In fact, I think the fire investigator, because we did look into this, the fire investigator, I think, said it was what did he say? A light that went nova or something like that. So a light in the basement or something sparked and caused this fire. And I don't have any reason to believe that Ms. Brophy did that intentionally or that she did it for some sort of insurance fraud. And that's just simply not what we're trying to approach. So somebody's opinion on that, we're not going to elicit that testimony. Also, this is the defense witness. They can limit the direct, and we have to stay within that scope.
All right, and then did you want to say anything about, and I'll be honest with the sides, I don't specifically remember this. I'm not saying it didn't happen, I just don't remember it. Questions regarding a financial interest that Ms. Brophy had in serving as her brother's executor in Texas. Does the state plan on eliciting that kind of information, or just how do you respond to that?
I do believe that it did happen. I think Ms. Weinmiller is correct that there was a line of questioning about Ms. Brophy's financial interest in being the executor in her brother's estate. The context was that the Brophy family in general, I think barring a couple of people, most of them are lawyers. And the question was, sort of why would Nancy be made the executor of her brother's estate 2 weeks after her own husband's murder? And so we were looking for some sort of financial motive as to why Ms. Brophy would leave the area just 2 weeks after her husband's murder. It was a really kind of a flyby question, if I remember correctly. I remember it, but it wasn't gone into any further. What I will say is the state doesn't have any current plans with any of the witnesses to explore that any further than we already have. Okay. And again, we have to stay within the scope of the direct. So if defense doesn't bring that issue up, then we really don't have any reason to address it.
All right, defense want to say anything further?
I do. Your Honor, the state has a copy of her brother's will and would know that she was the executor before her husband died. That wasn't something that happened in the sequence suggested. And you simply, as the court is well aware, being the executor is not a lucrative position. It is a labor of love. It's something one does for a family member out of care and concern. I am not aware of any non-bank, non-financial institution executor that's ever made money from that sort of thing. So I think the question was completely and entirely inappropriate. I would further say about they've got the fire inspector's report, so they know the date of the fire. They don't need to be fishing through witnesses like Mr. Denny, who first met the Brophies in late 2017, long after that fire occurred. There is an attempt there to insinuate that something bad has been done. That insinuation is quite clear from Detective Merrill's questioning in the report that we just got this weekend. I of course don't know how the prosecutors would intend to handle that, but it's not even subtle in the way that it's suggested in that interview report.
Well, so let me ask this. Does the state agree that Mr. Denny learned about the fire long after the fire had already occurred?
Yeah, because he didn't meet them until I think late 2017, didn't start work for them until early 2018 is what he says. I think the reason it's important with him, his understanding when the fire happens, because Ms. Brophy's reporting to him that they were recovering from a fire. This is what I believe he will say. I don't know for certain. That he would say that they were recovering from the fire and that they were tired. And that's why they didn't want to take on this backyard project. And that's why they were hiring him. That's his impression. I think the reason it's important to ask him about this because if Ms. Brophy's telling him that they just recovered from a fire and that's why they're tired, that fire happened like 10 years ago before.
Okay. All right.
So that would be the limited purpose, not some sort of insurance fraud. I don't know why they keep saying that. We've never.
All right. Well, I will say this, to the extent that the state would attempt to ask questions about a fire to imply that somehow Ms. Brophy was responsible for it, I would sustain an objection along those lines, and I'm instructing the state not to ask questions along those lines. To the extent the state is asking a question about Mr. Denny's understanding based on the statements of Ms. Brophy when the fire occurred, simply to set a point in time, I would allow such questions. To the extent the state is asking questions about Mr. Denny's understanding based not on Ms. Brophy's statements, but somebody else's statements, I would also sustain as hearsay. If either side feels a need to object when Mr. Denny is giving testimony because something else has cropped up, I'll hear the objection at that point, but that'll be my ruling right now. Anything else before we bring the jury back in?
We're just double checking to make sure we covered all the motions, Your Honor.
All right.
Your Honor, I'm wondering if apparently we don't have a copy of our own memo on lay opinion evidence, but that is something that could come up with Mr. Denny's
Oh, I'm sorry.
testimony.
Yes, we didn't. Yes, I
Well,
apologize.
And we asked you to hold it because we were trying to find the memo and not prepared. I'm wondering, maybe we could just take a short break, argue that.
Well, I
immediately when
can
we come back.
give you the copy I have since I've read it, because I'd like to try to get the jury in here.
Yes.
Here it is.
I've given him a copy.
Oh, okay.
Your Honor,
Can I just?
here's the problem. I'm feeling very uncomfortable because counsel still has symptoms, and I would ask that he not approach our counsel table.
Can you go over there? So I can do that.
I know, I'm sorry, but I just got nervous.
My understanding is that you do not have symptoms?
I don't. I have some allergy symptoms, Your Honor.
Okay.
As you might be able to hear in my. But I don't believe I have any COVID symptoms remaining.
Okay.
But thank you for bringing that up in open court.
But let's not bicker. Let's just keep our distance. And I guess I wanted to know, but before defense even makes their argument on this motion, I'm not certain if there's an objection. I don't know if the state is objecting to lay opinion about the health of the relationship between the two.
On that particular issue, Your Honor, we're not.
Okay.
As long as the witnesses can establish that they have enough opportunity to
Understood.
formulate that opinion, we
Then let me
understand.
see what else, because I think the reason why we put it on hold, Ms. Weinmiller, if I remember right, was more to do with the possible 8033 information. But if they're not objecting to the lay opinion testimony, is there anything more that we need to discuss today?
No, I just wanted to give the court an opportunity to rule before we ask Mr. Denny some questions.
Oh, okay, all right. Yes.
Your Honor, the other part of that motion was the Ms. Brophy's statements. They're asking to offer Ms. Brophy's statements under the 8033 exception.
Well, that was part of a different motion, as I understood it. I have already ruled that to the extent Ms. Brophy told various people that she had bought a gun kit, that would be admissible, but not the purpose for which she bought the gun kit. That was my ruling. Are you thinking of something else?
Yeah, and that's why I think I was headed with that, Your Honor. Sorry, I wasn't more clear. That we're not. We understand your ruling regarding the gun kit. What we believe defense is also asking to do is admit statements by Ms. Brophy to these witnesses about their relationship, about her.
Oh, I see.
And that's how they're formulating their
I
opinion.
see.
We would object to that.
Okay, so I guess we're talking about the parameters of lay opinion. Is defense seeking to elicit specific statements from Ms. Brophy to these various witnesses, such as we have a great relationship, we love each other,
Talking
or
about the witnesses today?
yeah,
Mr.
or
Brophy.
or at all, really?
Yeah, Your Honor, I think there would be times that witnesses we would ask witnesses whether our client had expressed to them her pride in her husband, the fact that, for example, that they were at a restaurant and she was so proud of the fact that he knew all the people who worked at the restaurant, that she thought her husband was really, really funny and she appreciated his sense of humor. There would be the fact that she loved him. There would be statements that she made to her friends about her marriage and her appreciation of her marriage that we would offer.
All right, so, but not today.
Not today.
Okay, so.
Oh, wait. Your Honor, I think the court should go ahead and rule because at least with respect to the witness, I'm not sure. where it
Okay,
would
so
head.
my basic ruling is this. Generally speaking, I'm not going to permit a witness to come in and talk about specific statements that Ms. Brophy made to them unless a clear exception is identified. But to the extent witnesses want to come in and say they've known the couple for however long they've known them, they've had a chance to form an opinion, and in their opinion is that they had a healthy, loving relationship, that I'll allow.
You know, again, I think that we would offer this to establish an absence of motive. In other words, a woman who's expressed her love for her husband is probably expressing the fact that she doesn't want to murder him. And we would offer it for her state of mind, her present state of mind at the time that she made the statements. We're not, we believe that for those purposes, it would be admissible.
Well, I think they might be. I mean, a lot of it depends on what specifically the statement is. So two ways we can do this. We can either have a 104 hearing with the witness on that limited topic to see what they're going to say, or, defense can talk to the witness before they take the stand, find out what they're going to say, and we can address it on the record. But I need to, in order for me to intelligently rule on whether something meets a hearsay exception, I need to know what the statement is and the context in which it's given. So maybe the best way to do that is a 104 hearing with the witness. Are you anticipating any of that from this first witness?
Mr. Denny is Ms. Weinmiller's. I don't anticipate that from Ms. Alva, who follows Mr. Denny.
Do you anticipate it with Mr. Denny?
I can certainly avoid asking him questions that would invite that, but he did talk with both of the Brophies, and I think he does hold their relationship in high estimation based on what he observed and what they said to him about each other and the way they worked together on what he would describe as a very, very difficult, challenging project, cleaning up their backyard. So I think for him to offer an opinion about the strength of their marriage and the quality of the way that they work together without getting into anything that either of them said to him about the other or in the presence of the other, it probably would be difficult for him.
All right, then I will rule that with Mr. Denny, he cannot make those kinds of comments. And I'll ask you to instruct him before he takes the stand. And just so I understand, Mr. Denny is not some friend of theirs. He's a person that was hired to do a job, essentially?
He was hired to do a job. That's how they met. They had not known each other before the job. It was such a big job, and he was there so many times that he did get to know them better than one would expect a landscaper typically would get to know the clients. But no, I think he fits in the category of
Okay.
somebody that they hired as opposed to a personal friend.
So you're not, I just want to make sure I'm following. You're not proposing that he had the sufficient basis to form an opinion as to the strength of their relationship over the period of time that he knew them,
Oh, no, I am proposing that he did because it was a very complicated project and he had many, many conversations with them.
Okay, I mean, certainly you can establish the contacts he had with them and whether or not he has an opinion. If the state thinks it's insufficient basis to form an opinion, they can object, and I'll make a ruling. But if he's allowed to give an opinion, it's simply his opinion about the strength of the relationship, not specific comments that were made to him by the parties.
Your Honor, there is one more issue that we've not touched on at all today, and that is the subject of exhibits. We got an email last evening indicating that the state plans to object to and does not want us to publish to the jury a couple of exhibits that we do plan to use with witnesses today. One is with the person I expect will be our last witness. She works with PPB for an organization called TIP or TIPS. They meet with the victims, as I'm sure Your Honor is aware, immediately following a tragedy like this, and they regularly, and did with Ms. Brophy, hand out a guide to help somebody through those difficult days and weeks following an event like this. And then the state apparently is planning to object both to our use of that guide and in specific to page 19 of that guide. That's our exhibit 237, and page 19 we pulled out as exhibit 237.1. I believe the court does have those available, and the reason that
Do we have those available? I don't.
There was a flash drive that we didn't get scanned until.
Okay.
they should have been on that much earlier flash drive too. I don't think those are new
All
this
right.
week. But in any event, it's a standard guide that's used. I don't know that PPB's reviewed it, but they certainly are the ones who call these people to the scene to offer this sort of assistance. And page 19 of the guide directs people, and including Ms. Brophy, to take some of the steps for which she's now been criticized by the state with respect to life insurance and the way one handles all of the affairs that need to be attended to after a tragedy. So we would like the court's ruling on that so that we don't have to disrupt that witness's testimony. And then the other,
When is that witness supposed to testify?
probably at the end of the day today.
Okay.
And the other witness today that I flagged after reading this email last night was our exhibit 260 and 261. It's a title report from Richard Freimark, who we intend to call today, and then the cover email to which that title report was attached. We thought that we had a stipulation as to property records relating to the Brophy home on 108th and Beaverton, so I'm not entirely sure what that objection would be, but we do intend to use that with that witness and to display it to the jury.
All right, so let me first ask the state with regards to 237, the page 19 of the TIPS guide, which I have not seen yet. Is the state objecting, and if so, why?
So, Your Honor, the point of this email was to address something that happened.
Well, this isn't an email, right? We're talking about page 19 of a TIPS guide right now.
Yes, but Ms. Weinmiller is referring to an email we sent defense after we received their exhibits. And in our email, we wanted to highlight exhibits that we were asking not be published to the jury before either a foundation had been laid or we'd had enough chance to object.
Oh.
And the reason for that, Your Honor, is that during our case in chief, there were times where we received exhibits emailed to us at lunch or various times during the day that they intended to use on cross. We had a brief chance to kind of look at them, but we didn't really know what they were. There was no context provided necessarily. And those were getting published to the jury, and there was at least one instance where we then asked for it to be removed before we had a chance for a foundation to be laid. All we were trying to indicate in this email is that these exhibits that we've listed out, we would like a foundation to be laid prior to them being published to the jury. That can be accomplished by defense handing the witness the exhibit so that they can review it first. Or I believe, and Ms. Liu may know better than I do, but I believe there's a way for the digital exhibit to be published just to the witness, and oh, there's not?
No.
So showing them the exhibit in some capacity first. With some of these exhibits, it's simply foundation. Just providing that the witness can actually lay the foundation. With that exhibit in particular, 237.1, we want to make sure that the actual exhibit that they have is the version that was, it appears to be the version from 2018 that was likely given to Ms. Brophy, but we'd like to make sure the witness can establish that that is in fact, has seen this exhibit, can say, yes, that's the version of our guide back in 2018 that was given to her, to lay a foundation in that regard. That's the same with the 260 and 260.1. These are exhibits that we just received some at various times in the last several days. But the point of sending this email to defense was to say, we don't want these being put up on the screen for the jury to see before the witness has laid a foundation.
Okay.
Once the foundation is laid, we may have no objection whatsoever once that's clarified to us, and some we may have an objection to. But what's been sort of previously happening, I think we are all doing it, was just kind of putting them up there. And so we wanted to try and address that from the start of their case and say, hey, these are exhibits we may have an issue with, we may not. It just depends on what foundation is laid. We just ask that they be presented to the witness, the foundation laid, before they're published.
So let me make sure I'm understanding. If there's going to be an objection, though, the objection is going to be inadequate foundation or something else?
It may be something else. It depends. Some of these, I don't know what they are. Like, we can see what they are, but we don't know, like, who took the picture. We don't know when it was taken. We don't know.
So let's talk specifically about 237.1. Are you anticipating any objection other than foundation, or you just don't know?
No, I'm not anticipating anything other, assuming that the witness can say this is exactly what I would have provided her or did provide her in 2018, we're not going to have an objection.
And then with 260 to 261?
Same thing, assuming that the witness can say, yes, this is my email that I sent, this is what was attached, these are the things I sent at this time period, this is from me, laying that foundation, we're not going to have an objection.
All right, so those are the only two things that defense had really brought up right now. We can deal with other things as they become apparent, but you know, I'll have defense hold off on publishing the exhibit until the witness can lay the proper foundation. Anything else? All right, let me ask the attorneys. We've obviously cut into a lot of time this morning. Do the attorneys need to use the restroom before we call for the jury? All right, then let's plan on being back on at 10:45.
And I'll have you take the bench before the jury is seated.
Yeah.
Oh,
Oh, right, and just so everyone knows, I plan on announcing to the jury that we have lost a juror. I'm not going to say why, but I'll make some comment about that's why we have alternates.
Your Honor, there is one additional exhibit that may be an issue, and we can talk
Okay.
about this right afterwards, but I should.
Well, I'd rather talk about it now so that we can.
Okay, I'm sorry. In this email, and again, we got this yesterday after the close of business, and so we're still observing it. One of the things that the state expressed some concern about were exhibits 244 and 257. Those were the state's insurance expert, Mr. Santos's original version of the insurance summary, and 257 is the state's financial expert, PPB analyst, Azor's initial financial graph, which the state had as its exhibit 108 initially before it replaced it with a more, with an updated version of 108. And those are both, I think, things that Mr. Overstreet actually displayed to the jury himself in opening statement. One of those, 257, is something that we potentially could bring up with one of our experts today as a point of comparison. But I don't understand why if he used it, it was pre-admitted, and he used it in his opening. I just can't understand
Well,
why
if
there
it was,
would be an
if it
objection
was
now.
pre-admitted, I can't imagine.
It
there's-
wasn't, Your Honor. Neither of these were pre-admitted. They are former versions of both Mr. Santos's testimony and Mr. Azor's testimony. Our objection to them is that they're inaccurate. Both Mr. Azor and Mr. Santos testified that they had made previous summaries or done previous versions of the exhibits that were ultimately admitted, and that those had been inaccurate. They realized their errors and had fixed them. And our concern is that we did not use these in opening, and we did not pre-admit them. We admitted versions of them as State's Exhibit 108 and State's Exhibit 65, I think. I can double check on that. But the versions that they have are old versions we sent them that we then sent updates for, and both witnesses testified when shown these by defense that those, yes, I did create that. I created it before I knew XYZ. I realized an error. 69, excuse me. So they are 244 is a version of State's Exhibit 69 that happened before State's Exhibit 69, and 257 is a version of State's Exhibit 108, but they are old versions. And the concern that we have is by admitting those, they're misleading and confusing to the jury because both witnesses testified that those documents are not accurate.
Let me, as I understand the objection, because I don't think inaccuracy is a legitimate objection, but I do think that, confusion of the issues could be. How is my recollection of the witness's testimony? I think Mr. Santos said he had done 5 or 6 versions before settling on the final version. So how is it defense is proposing to use an earlier version that he's already indicated is not correct?
Your Honor, these are both the exhibits as they existed when this trial began. The information in these exhibits is what was presented to the jury initially. I believe both of these were revised after we gave our opening statement, and they listened to our figures, and they had both of these experts go back and rework this information. So it is true that by the time they testified, they were testifying that they had updated their exhibits during the trial. And that these are not the current versions that the state is now relying on, but these are the versions that contain the information that was presented to the jury at the beginning of the case, and we absolutely have a right to clarify that and to make sure that the jury doesn't hold in their heads this lingering impression that somehow that was accurate information presented to them in the opening statement.
So when you say presented to the jury, I just want to make sure I'm understanding. What you mean is that the state made comments in their opening statement that you later showed were inaccurate?
Your Honor, we don't have a copy of Mr. Overstreet's opening and the exhibits used. These 2 exhibits were given to us for the purpose of making sure that he could use them in the opening, and my recollection is that he did in fact display them to the jury then. He certainly was working from them.
But I guess what I'm getting at is in any opening statement by either side, if you state something inaccurately and then later it's shown to be inaccurate, that's a risk that the attorney runs and something that can be pointed out by the opposition. But I guess I'm not fully understanding the relevance of a document which everyone has now agreed is inaccurate. And when I say everyone's agreed, and it's been pointed out by a witness, as I understand it, and not challenged. So I guess I'm having a hard time following the relevance of admission of a document that's already been flagged as inaccurate, but maybe I'm not totally following what you want to ask your witness.
Your Honor, the state's opening statement is a part of the case. It is information that's been presented to the jury. It's information that we need to refute. Everything that we're doing is impeachment of those 2 experts and essentially of the way that the facts were initially relayed to the jury. These are significant changes and significant inaccuracies, and frankly, it speaks, I think, to the care that was taken with respect to the entire investigation. The fact that they realized their mistake after listening to our opening and backed away from it shouldn't absolve them of any responsibility
Well,
for
no,
it.
I agree, but didn't you cross-examine Mr. Santos and Mr. Azor about this topic?
We did, and we are now bringing out in our own experts to continue that process.
And to be clear, Your Honor, I'm not objecting to them using them with their expert. We're objecting to their admission. They've already published them to the jury and referred to them. And our email is very clear. We're not objecting to that. We're just objecting to them being admitted and submitted to the jury because that is where it becomes misleading and confusing of the issues. Certainly, I mean, these were exhibits that were provided to defense when we provided all of our exhibits to defense pre-trial. They were not used in opening as exhibits because they weren't finalized exhibits, and we made that clear that they weren't finalized exhibits when we provided them to defense. So our objection is to the admission of those exhibits. Certainly, I think it's very fair that they can put their expert on and say, now look at this version of this report. What do you see that's wrong? And the expert can explain why it's wrong, although I think our experts already agreed that they were wrong. But certainly I think that they can do that and they can show them the chart and show the jury the chart because that's already been shown. But we're objecting to the actual admission of those because it's confusing the issue because the correct finalized version that our experts are testifying to have already been introduced and offered.
All right, I'll allow defense to display the exhibits when their expert is on the stand, allow defense to question their witnesses about the exhibits. I'm calling them exhibits, they haven't been admitted, but unless I hear something different, I'm not going to allow actual admission of the exhibits. So with that, is 10 minutes enough for a break?
I'm so sorry.
That's all right. But I want to give you enough time. Is 10 minutes enough time? Okay, so let's take a 10-minute break. Be back on the record at 10 till 11.
All rise.
All right, please be seated. I want to again thank the jurors for their patience. Before we start, just a quick announcement. We did lose one of the jurors for personal reasons. It's not unheard of in a case that goes this long. One of the reasons we had a lot of alternate jurors to begin with, but I just thought I would explain that. And we will now hear the defense case. Ms. Wyman.
Thank you, Your Honor. The defense calls James Denny.
Okay. One thing I neglected to say, I will say this too. Because of some of the delays, we may need to use some of the Fridays. We're not going to use this Friday, however, and we'll just sort of see how things go. All right, Mr. Denny, why don't you come on in and we'll have you step into this boxed area. But we'll have you remain standing after you step into the box, and my clerk will give you an oath. All right, Ms. Lou.
All right, I'll have you step up just a little bit closer to that chair for me, please.
It's because there's a microphone there. We just want to be able, we can pick up your voice.
Perfect, thank you. And I'll have you raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, then you may be seated. And you may remove your mask. And then because we're being recorded, I'll ask you to please state and spell your first and last name.
James, James. Denny, Denny.
All right, and Mr. Denny, there is a pitcher of water there if you want it. It's up to you.
Okay.
But whenever you're ready, Ms. Weinmiller.
Thank you, Your Honor. Mr. Denny, I'm over here now. So, do you consider yourself retired?
Sometimes.
Yeah. Tell us what you did for a living, or what you still do for a living.
I'm a landscaper.
Okay, did you do that your whole career, your whole life?
Started in the 5th grade.
All right. What's your business called?
James, Denny Landscaping.
And where do you operate that business? Where's that located?
Now, Roy Rogers Road.
And sorry, just to interrupt real quick. Mr. Denny, could I have you reach forward and pull that microphone just a little closer to you? Yes, thank you. All right, Ms. Weinmiller, go ahead.
Thank you. So it sounds like you're still operating that business.
Sometimes.
Okay. Do you know Nancy Brophy?
Do I know her?
Yes. Are you familiar with her?
Yes.
Okay. When did you get to know her?
She called me on the telephone.
Do you know about when that was?
Nope.
What's your best guess about the time frame? I'm not talking about the day or the week, but just...
Probably, I'm guessing 4.5 years ago.
Okay.
I want to say January. I can't remember.
Okay. And was she calling you because she wanted to hire you?
Yes.
Okay.
Guard.
Okay. Did she tell you, what was your understanding of how she decided to call you?
My sign.
Okay. Mr. Breton, would you pull up 328, exhibit 328? Is this the sign you're talking about? You see right in front of you there's a computer screen right there for you.
Yes, that's my sign.
All right, can you leave that up, Mr. Breton, please? And boy, I can't even see it myself now. Right. So she called you and she described you a job that she wanted you to bid, is that right?
Yes, yes.
Okay. Did you go out to the Brophy property and look at it? What was your first impression of the job?
Piece of cake. It was that's the type of jobs I like. Jobs that everybody else runs away from.
Okay, so when you say piece of cake, are you being facetious?
Yeah.
Okay. How did the front yard of that house look?
Hedges were overgrown. There was
And I'm talking right now about the front yard. I'm gonna ask you to talk about the front yard and then the backyard, okay?
okay.
Okay, so tell me about the front yard first.
The driveway was full of debris. I mean, lots of stuff.
Gardening type things or things unrelated to the yard?
No, they're mostly yard related.
Okay. And what about the backyard? How large is that property, first of all, from behind the house?
I don't know. It was big. Lots of blackberries.
Okay, and when you say lots of blackberries, were there blackberries through the entire backyard, or was that in a
Through the
particular
backyard,
section?
come through the front fence, side fence.
And what was your understanding of what you were supposed to bid, what the project itself was gonna be?
Well, I went by the hour and material, because I mean there's no way that I could give an honest bid, and that I'd be paid at the end of each day or thereabouts, pretty close. And
Okay, and then what specifically were you bidding to do to the yard? It sounds like you had to clear out the blackberries.
It's been a long time. I can't. The front yard needed work, but the backyard is where all the hardships were.
Okay, I'm gonna ask Mr. Britton to pull up for us Exhibit 204. And that should show up on that computer in front of you again. I know you've never been up in well, I assume you haven't been up in a helicopter or a drone above the property, but do you recognize the property that's not quite centered in the photo there? It's a little bit more toward the left and a little bit more toward the bottom of the photo.
I think.
Okay, does that look like the Brophy property in Beaverton that you were working on?
I think it is. I mean, when I came, it was needed a lot of work. When I left, it was ready to plant seed.
Okay, so when you look at that photo, does that appear to be the way you left it after your project was done, or the way it was when you first got there?
Minus the grass, it looks like it. After I left, that's what it looked like.
This is the after photo, not the before
I know,
photo.
that's what I'm saying.
Okay,
After I left, that's what this looks like. I don't think I planted grass. I might
okay.
have planted a little on the side. I can't remember.
Was it essentially ready though for grass or sod to go in when you
Very
left?
darn close,
Okay,
if not perfect for grass.
okay. So where were these blackberries? Can you know, there was a pointer up there and I'm not sure that that's there now.
It covered the entire yard. There's structures, there's a greenhouse.
Oh, thank you, I didn't see it. All right, so I don't want to inconvenience you by standing up, but would you mind just for a moment looking at, maybe you can do it even seated, but kind of pointing to the area where the blackberries were?
That's fine.
They were overgrown in this yard, all the way across, and overgrown through the fence.
Okay, when you say the fence, it looks like there's some kind of garden or dirt area there. Are you talking about on what would be the upper border?
Well, there was a fence there, when I was there was a fence.
Okay,
Blackberries were growing through it.
so everything that shows now as grass is where the blackberries were? Is that what you're saying?
Yes.
And what about that dirt area that's up above what's now grass?
Yeah, I mean, it was just completely blackberries.
Oh, the whole thing went,
Yeah.
both parts, okay.
Like I said, I think she tried to hire other guys. I think they came and looked and ran.
Okay, and so let's talk about the components of that job. You said that there was a fence in there in between the area that's now grass and the area that looks like dirt, completely cleared out garden. Was that a chain link fence?
Chain link was on the side of the house. I had to remove it to get my tractor into the backyard.
All right, and then did you also remove the fence that's no longer there between the grass and the dirt?
I don't think so. I can't remember. It's been a long time.
All right. In addition to clearing out blackberries and getting that dirt ready to be seeded or sodded or whatever resulted in that nice lawn that we see there now, what other work did you have to do in the back to get it back to a normal state?
I had to remove trees that were in the way of my tractor. There was stuff behind her deck that had to be cleaned off and removed. There's blackberry everywhere, and then there was, she had barrels that were cut in half with dirt in it that was used for plantings. A lot of work went into that. Was there, because I mean, at one time you could see there was, it's a beautiful garden.
Okay, and the barrels, what part of the yard were those barrels in?
Backyard. I don't know how many. I want to say, I really don't, I want to say 75 to 100, I don't know, a lot,
Many dozens.
lots. And then the only way I could remove them, I used my tractor to push on the barrels to break them loose from grass and blackberries.
Okay, were the barrels sitting right up on top of the dirt or were they partially submerged?
Partially submerged.
And about how far down were they dug in?
I don't remember. All I know is my tractor could move them.
Could you have done it with a crew of guys without a tractor?
No. My tractor has like a 3,000-pound push. That's how I was able to get the barrels out.
Do you remember about what time of year it was when you first went out to look at the job?
Don't remember. I think my first bill was in January.
Okay.
And I went whenever the weather was permitting that I could work and accomplish something.
Well, that's what I was going to ask you about. If you were using a tractor to try to dig out submerged barrels, what's the optimal time of year to do that kind of work?
April, May, June, July.
Okay, and why is that not something you'd want to do in January, February, March?
Because I do more damage than good with the tires on my tractor. I would have ripped things up and it wouldn't have been just smooth. I would have had tire ruts all over the place.
Because of the moisture in the soil, is that the
well,
problem?
That's why, it took a long time to do that because I worked as the weather permitted me to work. I don't work on wet property.
Okay, all right, so you went out there at some point. Is it safe to say that that was probably late 2017? If your first invoice was in January of 2018?
Probably.
Okay. When you went out the first time, did you meet with both Nancy Brophy and Dan Brophy, or just one or the other of them?
Can't remember.
Okay.
Might have been both. I cannot, it's been so long I don't remember.
Okay.
I know that I discussed things as I was doing the work with both of them.
Okay. And did you tend to talk with one of them more than the other one, or?
I talked more with Nancy.
Okay. And I realize it's been several years now, but can you give us an estimate of the number of times you talked with Dan Brophy about this?
I can't remember. All I know is that Nancy wanted to make sure that I didn't upset Dan when I was doing my work.
Okay,
Because, I mean, most people looked at it and they just want to haul everything away. And I knew that there's things that were important to him, so I talked to him a lot, but I don't remember how many times.
okay. And in the course of having those conversations with Dan Brophy, did you feel like the two of you came to a meeting of minds about how you would handle this job?
Yes,
Did you ever sense that there was friction between you and him about that?
no. The first time I was out there, I knew he was nervous about having someone come into his yard and clean it up. I reassured him that I just remove things that he told me I could remove. So like on the driveway, big driveway, so I put on one side of the driveway, I put stuff I thought he might want. The other side, I put stuff I thought he'd want removed.
Okay. And did you learn over time that your judgment about that was pretty good, that you did understand what he wanted?
Yes,
Okay. And what about Nancy Brophy? Did you feel like you were able to communicate well and work well with her?
yes.
And what about the two of them? To the extent that you were there talking with them about the same project, what were your impressions of whether their goals were compatible?
Had to walk a delicate line because, she wanted it all cleaned up. He wanted it cleaned up too, but there's things that were precious to him. I didn't want to remove something, then have him say that that was important to him. So, it, step at a time. That's how that job was.
Okay. And what was your impression of their ability to work through those issues together?
Good.
Yeah. Did you ever notice anything that you considered serious discord or bickering or anything like that?
Never.
I talked over you. I'm sorry about that.
Never.
Thank
Nancy she emphasized that she wanted me to make Dan happy. I mean, when someone comes in your yard to cleaned up, I mean, he had a lot of stuff there. A lot of he had lots of portable chicken coops that the blackberries grew in between, and he had lots of stuff that was important to him. So as I was working, I would try to I'd make sure that he was happy with everything I was doing, so he didn't feel like I just came in to bulldoze everything out. And on the hours, if I was on the tractor, my tractor, I can work really good on my tractor. Walking around, I didn't work that well, so my people were doing the work. I'd be there all day long, and I'd charge a little bit, but I wouldn't charge for the full day because I wasn't able to accomplish the work that I could when I was younger.
You're talking about your own time now. How
My
much
time,
your
yeah.
time? Okay.
Well, sometimes it's the hours for my people that might be 8, 9 hours. This one's all, I haven't really looked at it in a long time, but
Well, let me hand this to you. I'm going to hand you what we've got marked as our exhibit 327. It might be easier for you to see it on paper, but I'd like you to tell us what those are.
okay, the first one,
What, can you just flip through it first of all and just tell us what this whole stack of papers is?
well, the first one is blackberries, working on blackberries.
Okay, well, let me back up just one step with you, okay? I see that you've got your business name at the top. Is this whole set of papers here, is this all the invoices that you gave the Brophies?
I believe so.
Okay, why don't you glance through it and let us know if that does seem right?
I had Tammy do work, like if she was head determined or if she's doing something,
I'm gonna go through all of these with you in just a minute. Right now, I want to establish just that these are invoices that you
Yes.
provided to the Brophies, okay?
yes.
All right, Mr. Breton, would you pull up 327? Okay, on that first page, what's the date of that? When does it look like you first invoiced the Brophies for this job?
4th of January, 2018.
All right, and let's flip to the very last page. Whoops. Oh, I'm sorry, I've got two sets of this here. I might have given you, may I see? Here, I might have given you too many pages. Apologize for that. I'm gonna have this be confusing. Here, stop. There, that's a better set. All right, so now when you look at the last page, when does it look like you last invoiced them?
Like August 25th.
Same year, 2018?
Yes.
Okay. Were you able to complete this job before Dan Brophy died?
I can't remember.
Okay.
I think he died, and I think I had a little bit more left to do. It's been so long, I can't remember.
Okay, that's fair enough. That's fair enough. Now, how many, and you can refer to this if you want, and I don't need an exact number, but how many people do you think you hired to work on this job with you?
I don't remember how many. I know a lot of people quit after a day's work. They couldn't handle it.
Okay. Do you have kind of a ballpark of how many people you brought in over that period of time?
I'd have to study this, and I could tell you.
Okay, why don't you just glance at it? I do not need an exact number.
Okay, I had
estimate.
Tammy was there a lot.
And when you say Tammy, tell us who you're talking about.
My niece,
What's her full name?
Tammy A. I don't know what her last name is.
Starts with an A.
Yeah, I think so.
Alva sound familiar?
Pardon?
Alva?
Yeah, that's it.
Okay. Okay, so the very first thing you've got on that January 2018 invoice does say Tammy. So that's who you're talking about there.
Yes.
Okay.
Then I had Eddie. He didn't last too long. It was too much for him.
Just from paging through that, does it look like you had at least a half a dozen people working with you at one point or another?
I'd say so, but not, not all at the same time. Raul, he was there a lot.
He's hard to scare off?
Pardon?
Is he hard to scare off?
Well, he's like me. There's a job. He was going to get it done.
Okay. Okay. Do you remember now how much you billed in total for that job? Just
Well,
roughly, not to the penny, but
I'd have to look at the back page. I want to say 20,000 some dollars.
something above $20,000?
Yeah.
Was that one of the bigger jobs you've had in recent years?
Nope. I've done irrigation jobs at, I did a condo, it had 94 units. That was all irrigation. And I, probably charged 95,000 for that.
Okay, well, let's
A lot of
separate,
units.
let's separate your work into commercial jobs like the condo and private homes. Have you had a private home job that was the size of this one?
No. Well, maybe a couple. I mean, this is probably the worst as far as blackberries and having to remove stuff, probably the worst one I ever did.
Okay, and tell us again about how long you've been a landscaper.
Since 1959, when I was in the 5th grade.
Okay, so you put this job right up there as one of the worst, toughest yards you tackled in that entire time?
Yes,
Okay.
a lot of labor.
Do you remember, I'm not sure that you're gonna be able to answer this. Having thought about it for a minute, do you remember whether the job continued after Mr. Brophy died or what that sequence of events was?
My best answer is I can't remember.
Okay.
I don't want to, possibly, but I can't remember.
Okay, that's fair enough, sir. That, I don't mind that at all. Mr. Breton, would you pull up also Exhibit 265? Then he's gonna just run through those with you, and I'd like you to tell us whether those appear to be the payments that correspond to these invoices, or are those payments you got for this job?
Well, anything that had her name on it, and the amount, yes.
Okay. And can you, Mr. Breton, would you just go through that whole series of checks? Do you see any there that appear to you not to be for this job? Okay, I think that's it.
Yeah.
Does that look right? Are those all for this job?
She signed checks to me, so they had to correspond with what's here.
Okay, that makes sense to me too. All right, well, I think that's probably all the questions I have. Let me just check for 1 second. Yeah, I think that's it. Thank you, sir.
Thank you.
Oh,
They,
yeah,
if you could
they get to
stay
ask you some questions too.
Right,
Okay.
Sorry.
all right. Go ahead when the state's ready.
Yeah, thank you, Judge. Good morning, Mr. Denny.
Point.
You said that you identified those checks as checks that were paid to you from Miss Brophy. Is that correct?
Well, anything that had her name in a check
Okay.
corresponds with these, yes.
And those checks were provided to you from Miss Brophy?
Yes,
She's the one that paid you.
yes.
Did Dan Brophy ever pay you?
I don't think so.
And all those checks from Miss Brophy, those all came from an On Point credit union check?
I don't remember.
Okay.
I'd have to look.
Okay. You want to go ahead and look?
Pardon?
Go ahead and look, please.
Well, I think, Mr. Breton, would you pull up 265 again? Thanks.
And I'll draw your attention to the lower left of the check or the upper right corner as well. Do you see where it says On Point on there?
Yeah, no, I see the On Point.
Okay. And did all the checks come from that same account?
I don't remember.
Okay. Do you want to look through them? He has them up on
This
your...
year's got bills.
I believe he has them up on your screen there.
Okay,
And thank you, Mr. Breton, for assisting with that.
yep. 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 Okay.
And I think that might
Appears
be...
they all are On Point.
They appear to all be from Miss Brophy from her On Point account.
Yes.
Okay, thank you. And Mr. Denny, you stated you weren't sure if, or I think you settled on I don't know if you did much work after Mr. Brophy had passed. Is that correct?
That's correct.
Okay. And earlier in your testimony, I think you said that maybe you had a little bit left to do.
No, I can't. Well, after that question was asked, I can't remember if he was already passed away or, I can't remember the timeline there. All I know, I come to work every day and there'd be work. And my goal was to get it finished so that she could sell the house.
Okay. And I think you talked about when you were doing this work, and I think we looked at those invoices, we could see when they were dated. Are those, looking at those invoices, do those appear to be accurate to you? Like you correctly identified what days and times you
Yes.
worked? Okay,
Well, it was in my computer, so,
sure. And you kept accurate records of that stuff?
yes.
Okay. And so if I told you Dan Brophy died on June 2nd, 2018, does that sound right to you?
I don't remember when he died. If he died then I was working after the
Okay.
fact.
And do you recall that you actually did a little less than $7,000 worth of work before Dan died?
I don't remember. I'd have to total.
But your invoices are correct.
Yes.
Okay, so if I'm pulling this information off the invoices, you would agree with it?
Yes.
Yes, okay. And so a little less than $7,000 before Dan Brophy died, but you actually did over about $16,000 worth of work after Dan Brophy died. Does that sound right?
I'd have to look.
Okay. But just based on those numbers, would you agree that you actually did the majority of the work, a good majority of the work, after Dan actually died?
Well, the big money came in when I was using my tractor, when I was able to use my tractor. So,
Sure.
according to dates you mentioned, he evidently did pass away before I finished, which I was working. I didn't really comprehend what day he passed away. It's been so long, I don't remember.
Yeah, no, that's fair enough. I appreciate that. But I guess what I'm getting at is, would you agree that you did the majority of the work as part of that $16,000 that you were paid, as opposed to the $7,000?
Well, once I was on my tractor, then the cost went up, because then I was charging for the hours I was there.
Right.
Prior to that, there was a lot of handwork, rebarb to take out of the ground, barrel, and that was all handwork.
Sure.
And it was slow and tedious, and we went when the weather would permit.
Gotcha. Okay. You mentioned, I believe you said something like this, so feel free to correct me if I'm wrong or I misstate it, but you said that you could tell that it used to be a beautiful garden at some point.
Well, with all this, it had a greenhouse, all these tubs had, a lot of the tubs still had good plants in them. So none of them were dumped until I had permission to dump them.
So was there still a viable garden present when you were there? Just
No, you had blackberries.
Okay, you said there were good plants in some of these tubs.
Well,
so.
in the tubs.
Okay.
The blackberries grew over the tubs. They grew over and through the greenhouse. They grew through the fencing. Lots of blackberries.
Sure, yeah, I think we understand that this was pretty overgrown. So if you were to take out all that blackberries and shrubs and things, it sounds like you did, one could go back to gardening in that yard? It would be open and available to start gardening again without all that.
It could have a brand new garden or a lawn. It was ready for a lawn.
Okay.
Or garden.
Are you aware that Dan actually put in a garden again after you guys did some of this work?
No.
So you didn't see Dan's new garden in the spring of 2018?
I don't remember.
Okay. And that would have been before you did the majority of a lot of the work with your tractor. Sorry.
I don't remember.
Your Honor, he said he didn't remember.
The state.
If we could bring up 204, I think this is defense is 204. I'll have you look at your screen there. It's a map you've already looked at and talked about. I just want to ask you a couple of questions about it. Should pop up there in just a second. There we go. With that pointer, if you could you point to where the back fence line of the lot is?
Back in the tree line.
Okay, could you point to it with the pointer, please? Sorry to make you stand.
No problem.
So there's a fence in that tree line there?
There's a fence in there. It had blackberries all the way up.
Okay. And so is there another property behind that fence line?
There's a house and property.
Okay, that's not part of the Brophy property though?
No.
Okay. And how big of a lot do you, just an estimate, your best guess, how big a lot do you think that the Brophy
I don't
lot
know.
was? Okay. Would a half an acre sound about right?
I'd say at least.
At least a half an acre?
It was, I couldn't really see things till we had to get rid of the blackberries, then we had to get rid of the greenhouse, then we had to get rid of lots of rebarb that held up plants and things.
Okay.
We had to accomplish a lot before I just knew it went way back, blackberries, grass, whatever.
Okay. But you eventually got that all done?
Yeah.
Yeah, okay. So you got a good chance to see the whole property at some point when you
When
were
it
done?
was all done, yes.
Yeah. Now you said that Dan wanted to keep some items, keep certain things, but you didn't mention what those were. What kind of things was he interested in keeping?
Well, certain plants.
Okay.
He had a couple plants he wanted to keep. We'd put anything he wanted to keep, either went on the driveway on the right-hand side or up on the deck.
Okay, so he's expressed an interest in keeping some plants.
Anything he wanted to keep, I kept.
Okay, and those would be things like plants.
Plants and whatever. I found tools.
Okay.
So I didn't throw away any tools. I put those in the garage.
Okay. Anything else that he wanted to keep from the yard?
I mean, I didn't take before pictures. You don't understand why I can't really.
I totally understand, and it's been about 4 years, so I understand. I'm just asking what you can remember. So do you think he wanted to keep any of the planters, or did he just keep viable plants that he could pull out of the
Some
yard?
of the plants, we finally got, I didn't take anything away until he told me I could.
Okay.
He told me to get rid of stuff, then my little niece is a pack rat, so she took lots of stuff, the barrels that were cut in half, she took all those to her friends. So I mean, there's so much stuff.
Okay. But nonetheless, and I guess I'll just leave it at this, is nonetheless, Mr. Brophy expressed to you that he did want to keep some things.
Well, anything he wanted to keep, we kept.
I understand that. I'm asking about his desire to keep things. He expressed that to you, that he wanted certain things.
Well, Nancy wanted me to make sure that anything Dan wanted to keep was kept.
I understand what Nancy asked you, sir. I'm asking you what Dan asked you.
I did whatever he wanted. Yeah, usually I'd see him in the mornings when we talk and we go through stuff. If he wanted to keep it, kept it. If he gave me permission to remove it, then I removed it.
I think I understand.
There's just so much stuff. I mean, I think that was one of the loves of his life was his garden.
Yeah.
And then the blackberries came in and just destroyed everything.
Okay.
And then my job was to get it presentable so the house could be sold, which I did.
Did you go inside their house?
Yes.
Okay. In your opinion, did the house also need work?
I don't really remember. I remember they had a house fire that burned some of the house up. I don't know what it burned up. The kitchen was redone for a chef. So it was one of the most beautiful kitchens in the world.
So the kitchen was really nice.
Well, I'd live in the house.
And did Nancy tell you when that fire was?
No,
Okay.
I didn't know the exact time when it happened. I just know there at one time there was a fire, and I think that probably finished the garden. I think it probably took the hard way from Dan. I mean, when you get a certain age, it's like I have a garden at home right now, a big garden. My wife has dementia. I'm not going to garden anymore. I mean, I love to garden. I used to grow dahlias and vegetables, and I'm having a neighbor come up. They're going to do the garden work so my wife's not overwhelmed. So there's just so much garbage and blackberries in that yard that you couldn't really have a garden in there.
I think I understand. What about their garage? Did you see their garage?
A long time ago. It was full of stuff. I can't remember per se what was in there.
Okay. And I think you testified to this on direct, but you said that you never saw Dan and Nancy fight in front of you.
Nope.
Okay. And is that common in your line of work? I mean, do you often have spouses fight in front of you?
Sometimes.
Okay.
You know, anytime you're messing with someone else's turf, that's why I was careful. Whatever I did was acceptable to both parties.
Yeah. And I assume you try to do that in probably most of your jobs.
Customer's boss.
Okay. Yeah. And just real quickly, I meant to talk about this earlier, but you had that sign, but that didn't have your business name on it or your phone number, but that was your sign?
Yeah.
Is there not a business name and phone number on it?
Well, the county widened our road. So I had to take all my signage down. I got more signs than that. I had a lot of signs. I had to take it all down so they could grade right next to the house. So I do have, on my other side of the driveway, I have my phone number several times.
Okay. So that sign that we saw, that wasn't a sign that was up in 2018?
It was a sign, but there might have been a phone number under it. I can't remember.
Okay. But it also didn't have your business name on it, it didn't look like?
It was everywhere else along the road.
Okay. So I'm just talking about the sign that we looked at.
Yeah, well,
Okay. So you don't know if that's the sign that,
that's the sign that has brought me most of my business.
okay. Without a phone number on it or a business name?
Yes, the phone numbers. I live on a 110-acre farm, so along the road's a long distance, and my number was, I sell firewood. I had numbers, my phone number was there. My phone number is probably, I don't remember how many, 5, 6 times for sure on the front of the property.
Okay. And were you scheduled to have dinner with the Brophies on June 2nd, 2018?
Don't remember.
Now, do you recall telling the detectives in this case that you didn't start work on the Brophies property until January 4th of 2018?
Possibly. I mean, I can't talk a long time ago.
Yeah,
I'm
sure.
73. I don't remember it happened last week.
Okay, fair enough.
And it was hot when we did the job. I had some water in the truck, and it was just really hot. And it was so hot working there, I actually drank the hot water and I enjoyed it. That's how hot it was.
Okay.
When I was doing
I'm
the-
assuming you're referring to the summer of 2018 when you say that, not January.
Yes.
And then I just want to be clear on these invoices, and I'm gonna let you go then. When your computer generated where it says labor and then a name, like Tammy, that's what you're billing Miss Brophy for those hours?
Yes.
Okay. And then when there's numbers in the quantity section, those are referring to how many hours one worked or how many of a certain item you used? And specifically, I'll point you to invoice number 588.
I put the, I had someone's name like Eddie.
Mhm.
I had 9. Ten, 975 to 245. That's the hours he had 5 hours. Under that I had that day I had 9:45 to 1 that day. So I didn't work.
Sure, and I guess what I'm asking you, sir, is under the quantity column, when you have a number there,
Yeah.
that's the amount of hours that person
That's the
worked?
amount of hours, yes.
Okay, and then where you have a number and it says something like blade for trimmer, you're just saying there's one blade for a trimmer.
Well, I got miscellaneous, so
Right.
blades for the trimmer.
Okay.
I mean,
But the whole point
$30, there would be several blades and, blackberries destroy blades.
Sure, I'm just trying to make sure I understand the invoice, what the invoice is relaying. And then when it says bill to, most of these say to Nancy Crampton Brophy.
Everything was.
Well, except there's some invoices in here, sir, that say somebody else's name. Specifically, Tammy Alva,
Well, that's my niece.
bill, but you're
So-
putting this in the billed to.
Pardon?
In the bill to section of your invoice, there's different names other than Nancy Crampton Brophy. And I'm looking at invoice 581, where it says bill to Tammy Alva.
Yeah, I think those might be the pages I took off of his copy.
Didn't give them to him,
Those are the ones that I went up and tore off.
so he doesn't have them.
Yeah, I don't think he did.
This is how he's paid her.
I think they
Doesn't
did.
have it.
Oh. You might not have them there.
These are the ones I took back.
Okay, do you mind if I just?
No, yeah, go ahead.
I think council didn't provide you with these, so I'm gonna provide those to you. I don't think they're in that pile.
Okay, this pile is everything that was billed to Nancy.
Right, so the ones that I just handed you, could you look for the invoice 581?
Yes, well, that was
Okay.
to my niece.
Right, but it says bill to Tamara Alva, or Tammy Alva.
Well, that's just,
Is that just a way for you to do your accounting?
yeah,
Okay, so when you say bill to Tamara Alva, you're not billing Tammy Alva.
no,
You're just documenting that you owe her that month.
I had to pay her.
Right, okay. And the same thing for 582 on, looks like Heriberto Quinones?
Yeah,
Same thing, right?
same thing.
Okay, so if we see another name other than Nancy Crampton Brophy, that's you accounting for those people's
Make out a
hours.
bill to my people, let them know how many hours they had, and then that's what I owed them.
Okay, thank you. And again, sir, I'm just trying to understand what these invoices are attempting to say. So that's why I'm asking these types of questions. And you, in fact, have one billed to yourself. That's just to account for the amount of hours that you work.
Not hours I worked.
Okay.
That's all I could remember things.
All right,
So
makes
that
sense.
could
I just want to make sure we understand these invoices and we're not getting them confused. And then final question on these invoices, sir, and that is, when you're billing Miss Crampton Brophy, you're billing at a rate of $35 an hour for your helpers, and then
I paid my helpers whatever the amount, 20 or whatever.
right. So when we look at these ones that say bill to another person, it's at
That's
$20
what-
an
That's what
hour.
I paid that person for
Right.
that day's work.
Okay, so you charged $35 an hour, but you pay your workers
You gotta
20.
make profit, or you're gonna go out of business.
I get it. I'm just making sure I understand the
A lot
invoices.
of, a lot of times I was there, I didn't charge because I wasn't able to do the work
Okay.
that I normally would. When I was on my tractor, I could do lots of work. If I was running stuff to the dump, I was able to do work. If I wasn't able to do work, I didn't charge for my time.
That makes sense. Okay, thank you. I think that's all the questions I have for you.
Thank you.
Just a couple
Just
more.
1 minute, Mr. Denny. Ms. Weinmiller may have a few more questions. Go ahead.
So the invoices that you were just looking at, the ones that you use to help yourself with accounting, what you were gonna have to pay your helpers, would you look at both 581 and 585? Especially 581, that's the one for your niece.
Yep.
Now that indicates that you, if you look at those two together, doesn't that indicate that you and your niece started working in December?
They have.
You see on 581, the first couple of line items appear to be dates in December.
Yep.
All right, and the same's true on your own, the one where you're keeping track of your own time, 585. We got an entry there in December too.
I see everything for Tammy.
Okay. So when we add up how much you got paid for the job, we should look at those checks and not try to add all these numbers together,
But
correct?
this here is just what I put down for my employees so I can remember how many hours they worked. And every so often they give her a bill for, I had a backup of what I paid them.
Okay, that makes sense. And so the pages that I took back and then he brought back up to you, those are the internal accounting pages.
Yep.
And the ones that you had initially, you're looking at were the customer bills.
Yes.
Okay. You mentioned that you had some conversations with Mr. Brophy pretty early in the morning. Were you kind of an early bird getting to this job? What time would you get there?
7 or 8 o'clock in the morning. I can't remember.
Okay, and you would catch him before he went to work sometimes?
Well, yes.
When you did that, would the two of you sometimes just have conversations, the two of you without Mrs. Brophy, without Nancy Brophy there?
Yes.
How many times do you think that happened, that you and Mr. Brophy were back there talking
Don't
without?
know. All I know is she emphasized to me, make sure I took care of him. That's what I did.
Okay,
I didn't want him to. I'm a pack rat too. I collect things. I got lots of buildings to put stuff in, so my stuff's not laying all over. I got 50 years of treasures in my buildings. So I knew anything that I removed from that yard, he had to be relaxed. That he'd know that I wasn't gonna throw stuff away that he wanted to keep.
okay. And you
I went on my
knew,
way to do that.
you knew that he had loved that garden?
Yes.
Okay.
Well, I mean, the whole thing was a garden. The whole thing at one time was a garden. And I mean, I could tell someone put their whole life into that. You know, they love gardening. I used to love gardening. I still love gardening. But I got 2 replaced knees. I can't bend over anymore. So if I do a garden, well, I'm not doing a garden anymore. I'm letting a neighbor come up and do it because I can't do it anymore. And that's my, I used to grow dahlias.
And for Dan Brophy, did you feel some commonality there? Was it your impression that that garden had just become overwhelming to him? It had just gotten away from him?
Well, I mean, all you had to do is look. I mean, if you look, you don't grow blackberries in the garden. And he had greenhouse. He had lots of portable chicken deals he moved around.
Okay. And could the two of them, in your opinion, when you got there and saw that property before you'd started all this handwork, and then eventually when the weather got better, you were able to bring the heavy equipment in, before all that happened, do you think that they could have sold the house at a fair value, that they could have maximized their profit for the house in that?
No,
Objection, Your
backyard
Honor,
was-
there's been no
the backyard
discussion
was a
about
total
selling the
mess.
home.
Hold on just a minute, Mr. Denick.
There was no discussion about selling the home on direct or cross.
Your Honor, it did come up on cross. It's true, I didn't raise it on direct.
On cross, hold on just a minute. I'll allow him to answer the question.
Your Honor, and just a further objection, I believe he may have made a statement, but it wasn't in response to a question, so can't open the own door.
I'll allow him to answer the question, but I'll also allow you to ask an additional question as far as recross.
Okay, thank you.
All right, you want to repeat the question?
I will. Mr. Denny, you've lived in Oregon a number of years.
73.
Do you, based on your experience and your view of that property, when you came in to bid that job, do you think that they could have sold that house in that condition at a good price?
No. I mean, the backyard was overwhelming. It was a nice house, but the yard was terrible. So to get, you know, sell a car, you gotta wash it.
That's a good point. Thank you, sir. I appreciate it.
Anything further from defense?
Oh, I'm sorry. No, Your Honor.
I'm gonna allow the state to recross on that one point. I'm gonna allow you to redirect on that one point, depending on whether or not you want to, but go ahead for the state.
Mr. Denny, are you a realtor or have you ever been a real estate agent?
I've been no. Okay, no.
And so do you typically, well, I guess I'll leave it at that. That's all. Thank you.
You want to redirect on that?
No, I don't, Your Honor. Thank
Okay.
you.
May Mr. Denny be excused? First I'll ask defense,
Yes.
and then for the state.
Yes, Your Honor.
All right, Mr. Denny, you can step down. Thank you.
Thank you.
If you wouldn't mind putting your mask back on as you go. And then we will take our lunch break. We'll plan on being back on the record at 1:30.
We will go off record and I will.